Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 148 153C. The name of the case is DINAKARA SUVARNA versus Deputy Commissioner of Income Tax, and the case has been reported in 454 ITR at page number 21. The matter has been decided by Karnataka High Court and the date of the judgment is 8th July 2022. This case has been decided in favor of the assessee. The department has gone into the special leave petition, but the SLP has also been dismissed by the Supreme Court of the department. The facts of the case are very interesting. In this case, a search was conducted on a person named AG. In that search, a diary was seized, and the person to whom this diary was belonging has died on the date of the search, meaning thereby that that person was not alive on the date of seizure of the diary. After this search and after collating the information from this search, a survey was made on different assessee for which this case is being discussed. And when that survey was made, in that survey, the person on whom the survey has been made has admitted that assessee was having an additional income of 8% of the receipts. But the assessee didn't file the revised return, so the department didn't get the tax on that. After that, the department basically relying on the two information. First, the admission by the assessee, and the second, the diary which was seized in the search of other person. On the basis of that, the department issued notice under section 148 to the assessee. The assessee raised the objection and said that any admission by any person cannot be used as the sole evidence, and the diary on which the department was relying, the author of that diary was not in existence on the date of the search, so that person cannot be produced before cross-examination. So the basis on which the section 148 is issued does not lie, so there is no legality of issuing notice under section 148. The assessing officer was not convinced with the assessee. He made the addition. When the matter came to the CIT appeal gave relief by saying that section 148 does not have the jurisdictional sanctity, but the ITAT reversed the order of the CIT appeal, so the assessee was before the High Court. The High Court affirmed the order of the CIT appeal by saying that in this case, the notice under section 148 was not justified because the statement of the assessee cannot be the sole basis for issuing the notice under section 148, and the diary on the basis of which the notice has been issued to the assessee, that diary does not have the evidentiary value because the author of that diary was not in existence on the date of the search and on the date of the seizure of that diary. Apart from that, the court also held that in this case, the person from whom that diary was searched or the diary was seized, on that person also no additions were made. So on these basis, the Karnataka High Court said that the notice under section 148 to the assessee is not valid, and there is a specific section 153C, which applies for those cases, for those assessees whose information is found at the person on whom the search is made. So in this case, the section 153C should be triggered in spite of section 148, because section 153C is more specific section than section 148, and it is a general rule of law that the specific provisions always prevail over the general provisions. Friends, this case is very important as far as the assessments under section 148 is issued and section 153C is concerned, because it happens that the department rely on the statements very heavily without any evidence. So the statements without evidence does not have any evidentiary value. At the end of this video, once again I am repeating the name of the case. The name of the case is DINAKARA SUVARNA versus Deputy Commissioner of Income Tax, and this case has been reported in 454 ITR at page number 21. The matter has been decided by Karnataka High Court. The date of the judgment is 8th July 2022, and this matter has been decided by Karnataka High Court. Thank you, friends.